So to start, thank you everyone for joining us for legal issues in COVID-19. Before we begin, I will just go over a few housekeeping Zoom guides. First, all participants will be muted. This session is also being recorded, so it will be posted to the news and media section on the Law School's alumni website. Feel free to turn off your video or change the way your name appears if you prefer. And lastly, please submit your questions using the chat feature at the bottom of the screen for Adam and Will. And with that, I will turn it over to you guys.
Great. So, hey everyone, thanks for coming. Just as a bit of background on this, if you were hoping for a well-prepared, thought-out presentation on exactly what's going on, you might be slightly disappointed, and then that's not what we've been up to. Instead, I think as most of you know, the law school has a pretty big tradition, and a pretty big part of our culture is regular lunch talks for the students. One upside of our law school being in a bit of a food desert is that we have such active lunches nearly every day. So at the start of this quarter in early April, Will and I decided that we'd do a weekly lunch talk to talk through various issues that are going on and invite all of the students to join us and debate whatever legal issues are taking place. Now, as perhaps some slight background for those of us that don't know us, Will and I have some different perspectives on these issues. So I guess sort of the simplest explanation, do law and economics research. I study the effect of laws, try to mostly do it empirically. Will tries to figure out what the law is and is a public law scholar interested in constitutional law and statutory interpretation. I think both of our politics are slightly difficult to put into any one box, but a safe bet might be that if there's a 5-4 decision at the Supreme Court along the partisan lines, that Will would think right now it's not such a bad idea, and I would think it's terrible. And so that's been sort of part of what's been going on in these debates. Anything to add to that, Will, before we jump in?
I think those are the nicest things you've ever said about me, so I'm glad this is being recorded.
That was not meant to be a compliment. Yeah, all right. So I get the nicest thing I've ever said is that you study what the law is. That might be right. All right. So here's what we thought we'd talk about today. In I think maybe our first talk, or first or second, we were talking about the courts, whether or not the courts would step in to strike down any of the stay-at-home orders or much of anything else. And I said something to the effect of, I thought it would be the case that maybe on some of the political issues, like the voting cases, that the courts would get involved. But in general, the sort of stay-at-home orders and lockdowns, the courts wouldn't be particularly interested in getting involved in that. Now, in the last week or two, that prediction seems to have gone from bad to terrible, in that Wisconsin, on a 4-3 decision, the Supreme Court of Wisconsin has struck down their stay-at-home order. In Illinois, we have a decision that's supposed to be handed down on Friday that it looks like is going to, the judge has been publicly signaling is going to strike down our stay-at-home order. There's been a state issue in Oregon, lawsuits in Maryland, Pennsylvania, Ohio, all across the country in state and federal court. And so we thought maybe we'd start by talking about what's going on there.
Yeah, I think we should especially start talking about Wisconsin. So I think already we've gone through several phases of our predictions being wrong. I think when we first started talking about this, one question was, how long will it be until any judge, issues a decision that does more than, nibble around the edges, deal with a church issue or a gun store? And I think neither of us thought there was going to be a sort of total broadside against stay-at-home orders for a long time. Then weeks ago, we started having a few of these decisions, like a decision in downstate Illinois, saying that the Governor Pritzker had exceeded his statutory authority. But it seemed like, okay, that's like one judge, and it's obviously going to be reversed on appeal, So now the Wisconsin Supreme Court, from which there is no appeal on questions of state law, has spoken, right? So they've said 4-3 in a case that I guess is named Wisconsin Legislature versus Palm, because Wisconsin allows the Wisconsin Legislature to sue in the Supreme Court as an original matter, has said that Wisconsin stay-at-home order is unlawful, and as far as I can tell, Wisconsin bars are very popular. So would you read this, Adam?
Yeah, so I read the decision, or most of it at least, I should say. It's 161 pages long of Wisconsin administrative law. So there was some skimming in the middle, but I found it, everything about this decision is bonkers to me. It is totally wild. And here's why. So I was reading through the majority opinion and was thinking, this is confusing. And it's essentially saying that the issue is, it's the acting Department of Homeland Health and Safety, Andrea Palm, issued an order that sort of laid out the stay-at-home rules about travel, what businesses can do, et cetera. And the majority decision is saying that this is problematic because it's an order, not a rulemaking process. And I was reading the majority opinion and thinking, this is sort of confusing to hinge everything on this. Until I got to the dissenting opinions, and there's two things that are just super crazy about the dissents. Thing one is that it's a 4-3 decision, and the Chief Justice who wrote the majority opinion also issued a concurrence saying she wishes they could have stayed the order, but it's a shame that they can't. And what's wild about that is the 3 dissenting judges, the 3 liberals, all say at very least we should stay this order. And so the Chief Justice is saying, if I had my way, I would have stayed it until May 20th, but we're not going to. Which makes it seem as if there's 4 judges that are voting to stay it and saying in writing that they're voting to stay the order. But for some reason, that didn't happen. Which not only is sort of weird procedurally, but really just exacerbates how partisan this looks when one judge is saying, like, I have no choice but as a conservative judge to vote with the conservative legislature against the Democratic executive branch officials, and won't even vote the way I'm saying in a concurrence we should to stay this order. Did you catch this part?
I did. So let's start here before we even get into whether it's right or wrong. So yeah, I think this is sometimes called Justice Kennedy syndrome, where Justice Kennedy would join a majority opinion in full and then write a concurring opinion saying, here's what I think, and you'd be like, this does not look like the majority opinion you signed. Which is it? So I see that. I'm not sure it's as indefensible as it sounds for 2 reasons. So one is just as a matter of like, why would a judge ever do that? Provide the 4th vote for an opinion and then say, gee, I wish I didn't have to do this. You might think that given how confusing this is and given how, given the stakes, that it's really important that the 4 members of the majority speak with one voice. So you might think that even if technically she has the power to sort of split the decision by partially joining with the dissenters on a delay and then joining the majority on something else, that's just going to create confusion and undermine the authority of the decision. And in a way, the more bonkers you think the decision is, the more important it might be that they at least try to maintain some kind of order and unanimity. So you might think that, yeah, the worse it is, the more important it is to speak one voice. The other is, so technically, here's what I read her saying in her concurring opinion. She says, this is on page 38, I think, before they're even getting started. Although our Declaration of Rights is effective immediately, I would stay future actions to enforce our decision until May 20th, 2020, which is today. So I think she might be saying there are sort of 2 parts of this. One is us saying what the law is, us telling everybody this is illegal. And that happens now when they issue the decision. But to the extent you're going to try to hold anybody in contempt or get any kind of like legal relief, that has to wait a week. So she's trying to split, because the decision is largely, doesn't actually consist of any remedy. The decision just consists of the court saying this is unlawful. And there's this point made in one of the opinions, like, how could you delay that? How could we say this is unlawful, but it's only unlawful in a week? So it may technically be okay, but then the dissent saying like the Chief Justice needs to clarify her opinion is really confusing because, you read her opinion, it's not very clear, and the dissent being like, you should clarify, and then it all just comes out without any clarification.
Yeah, no, I mean, I see something to what you're saying, but are you implying, do we think that if the secretary in the executive branch in Wisconsin said, all right, this order's come down, and as of midnight on the 20th, you can reopen your businesses, but for the next 5 days, we're going to try to get some guidelines in place or take some various steps to prepare or to issue new orders or anything else, that would have flown? That's what the Chief Justice is like, at least leaving open that possibility?
I think that's what the Chief Justice is saying, is saying if they tried to do that, yeah, they would have had a week to keep enforcing the order. Now, I gather that didn't happen in part because once the Wisconsin Supreme Court ruled, everybody who didn't want to enforce the order started rushing not to do so. I think that's what she was trying to do.
Well, there's a pretty easy way and clear way to do that if you're the Chief Justice, which is you just hold off publishing the decision until the 20th and then signal in some way that this is likely coming down, right? I mean, that's the way that you so that you have until the 20th to get ready.
Right. Although if you want, I mean, that's the confusing part. I think if you want to tell people this is what's coming down and this is why, if you have some time before you get ready, then you kind of need to let them see the decision. And stuff like leaking it in advance is sort of so unusual that just, I think, makes it seem more illegitimate.
I guess. I mean, I don't know. It's all a tie for bizarre and the way to do this. All right. So what about the substance? What did you think about the actual argument? Did you end up going and reading the statute, by the way?
Parts of it. I can't say I've mastered Wisconsin administrative law, but I think I have the statutory rules.
Here, I'll paste it into the chat if anyone wants to take a look. It's section 2502 and 2503 are the relevant pieces here. All right. So what did you think of the substance of the ruling?
So I don't think the substance of the ruling is that bonkers. I mean, I guess the big question is a framing question, is to what extent should we think of this as an emergency powers case, and to what extent do we think of this as an administrative law case? Because I think if you think of this as just like the normal rules of administrative law applying, you've got an administrative agency doing something, and Wisconsin administrative law anticipates two kinds of things agencies can do. Rules, which affect everybody and are kind of like law, and therefore we might want the legislature to at least get a chance to think about them before they happen. And orders, which are more like executive actions, close this meatpacking plant, which have to happen now and the legislature can't be expected to weigh in on them. And this, which affects the whole state and looks like it basically just like totally changes the legal regime of Wisconsin. It's more like law, so maybe the legislature should at least get to look at it. Right? That's the underlying theory.
Yeah, I guess. But so part of what the statute says here is that, which the majority opinion doesn't even reference, even though, which is the 252.03. One is to say that if you find a health problem, that you should take steps to make people safe right away or whatever. It seems like that there's all of these broad grants of authority in the statute. And the majority opinion relies on this rule language to the exclusion of all of these other clauses that seem to grant extremely broad authority. And now what's confusing in this case, though, is not only did they have to ignore what seems to me the more direct reading of the statute, that the people that are complaining about the reading of the statute are the people that have the authority to rewrite the statute. And so if they don't like it, it's the Republican-controlled state legislature in Wisconsin, it's the plaintiffs in the case. They can just go rewrite this thing and take away the statutory authority. Now, you might think it's difficult to vote in a pandemic right now and that they don't want to go to work or something, but no one has less moral standing in the country to say that you should have to go cast your vote during a pandemic than the Wisconsin state legislature. So
give you that
why
one.
don't we go change this?
Well, so I mean, I feel like so in any statutory interpretations case, both sides want to say, look, if you don't like it, change it. And so everything comes down to what does it currently say? And I think that the substantive Wisconsin grants of Wisconsin law are super broad. They say, yeah, in an emergency, the health officers should take all the appropriate steps. But that doesn't tell us procedurally what procedures they have to go through to take those steps. Like if they decided, that, I mean, the same way that when they decide to prosecute people for like unsafe practices, they still have to go through some kind of a trial or something like that. And so I think the theory is if they decide the measure they need is effectively a legislative rule, then under Wisconsin administrative law, they have to at least give the legislature a chance to weigh in on it before it goes into effect. Right? That's, I think, the substance of what was supposed to happen, or the procedure of what was supposed to happen, was Palm was supposed to go through notice and comment rulemaking where the Wisconsin legislature has a role in the process. And the complaint is that she didn't go through the right process, and so she can't impose a legislative order on the whole state.
All right. The notice and comment and rulemaking process, though, that they talk about and that they envision is a slow one. And so my reading of the statute is that you both talk about a rule and then you add all this other language to deal with situations where things are fast moving. And that actually seems like a reasonable kind of balance to me to deal with. The situation is to say, like, if what we want the order to be something about salmonella chicken factories or whatever that we have time to actually implement, we'll go through notice and comment. But if we have an emergency situation where we initially have R greater than 1 and exponential growth of the spread of a virus, then you've got these extra powers to stop the disease and stop the pandemic, right? And that seems like a reasonable breakdown to me, and why they would have concluded, had the possibility of more than just rulemaking, right? And so what's this in the statute for, if not for COVID? What's the other scenario where you need the ability for the spread of a disease to issue orders and take emergency actions?
I mean, again, so I think the most natural are for things that are not quite as widespread of a pandemic. So you discover that rather than the global pandemic we have now, like 2 of your local meatpacking plants have an outbreak of E. coli or whatever, shut them down right away, right? Or even like a school where suddenly everybody has the measles, you can like step in and just close it right away. If it's something that affects everybody, I think it's different. Now, I will say there's something else in the majority opinion I didn't understand, and I realize I'm supposed to be trying to defend the indefensible here, but they do say, well, look, if you have this situation that you were just describing, where you need a rule right now, we have emergency rulemaking procedures, so she should have used those. Those, I gather, can go into effect right away. So I think, am I right on what's going on here? Palm could have used emergency rulemaking procedures, said, yes, this is a rule, but I don't have time for notice and comment. But the price for that would be that the rule comes to the built-in sunset. It sunsets after 150 days. And because she didn't want to do that, because she didn't know she was going to need it for longer, she can't use the emergency safe harbor. Is that the idea?
Yeah, it seemed like that's what they were saying. So here's a question I had about that, though. Can Palm just go ahead and issue that emergency order now? I mean, is there any problem with that?
I mean, so good. So this gets us to the second part of the opinion, right? So I think procedurally, the procedural part of the opinion, I think that would be fine. I think it would be fine for her to say, all right, I now issue an emergency order, no notice and comment, and I'll reissue my original order subject to notice and comment. So we put the order back into effect in the legislature for 150 days, and the legislature can think of whether they want to do it. And I think that's what maybe the stay could have been used to do. Except that then the majority goes on to write a second half of their opinion to say, let's assume that we're wrong about all this procedural stuff. Also, the order is unlawful because it governs way more stuff than public health. It governs way more stuff than the communicable disease statute lets her govern, right?
Right.
And this, I assume, is the part that you're really objecting to. I think their theory is under Section 2252.02, which they're more interested in 03,
right,
has the ability to do things like tell people who are either infected or suspected of being infected. So you could do quarantine again everybody who works at a meatpacking plant, but you can't just decide the whole state is suspected of being infected, and so this is just like too broad of a quarantine. Does that seem right?
Yeah, no, but exactly. So it seems to suggest, though, that if what you have is a fast-spreading infectious disease, that you actually have almost no power to fight that, right? Because they try to imply that the limits on this power are to like quarantining people once you have something that's more like specific evidence that they might in some way be targeted beyond just that they're generally in the state. And so it really does seem to rein in the substantive authority that you would have.
And I guess, yeah, this part, I mean, this is the part that I don't know very much about epidemiology, and we've learned the lessons of law professors trying to pretend they're epidemiologists.
Yeah.
But it did seem like the majority wasn't taking into account of the basic structure of how a pandemic like this works, where you just need to in various ways make it so that each person who has this disease on average infects less than one other person. And if we knew who all the people who were infected were with perfect certainty, and we're willing to do anything to them, we just quarantine them, for 14 days and shut everything down. But because we don't, we therefore need to take a lot of broader steps, including shutting down, whole groups of people who may well not be infected. But it wasn't clear on the majority sort of like understood how you're supposed to fight an infectious disease. That said, one thing did emerge, which again, this Wisconsin legislature point, in 2011, they tell us, the Wisconsin legislature did amend the Wisconsin Administrative Procedure Act by imposing an explicit authority requirement on all interpretations of agency powers. saying no agency can do anything unless we implement any standard requirement or threshold unless it is explicitly required or permitted by a statute. So it seems like they've adopted a kind of like anti-Chevron rule that if the language is ambiguous, the agencies lose. I guess if Wisconsin wants to do that, they can, right?
Yeah, it is a weird kind of rule to have in general, right? That legislature can write unclear rules and then reserve the right to sue in court or something like that directly to the Supreme Court. Especially in this case, you have the majority of the legislature that's bringing the case. It's, the Republican majority that's doing it. But you could easily imagine the minority doing this too and trying to just constantly chip away at executive authority if you had the votes in the Supreme Court.
Right. Although again, you might think maybe our usual rules are reversed. Our usual rules to say to the executive, when in doubt, do it, and we'll try to stop you. But if you have a political process where you frequently have gridlock or mismatch between the executive and the legislature, it's not crazy to say, look, we need to reverse. We need to say, we have a lot less power, and if you need something, come and convince us that you need it.
Right. So both of the Illinois case and the Wisconsin case, they're both ad law cases, right? They're basically saying that it's not a constitutional claim that's a problem. It's that it's overstepping the statutory authority of the governor in the case of Illinois, or the Secretary of Health and Safety in the case of Wisconsin, that they're overstepping their statutory authority given by the legislature, right?
So in both these cases, if the legislature wanted to, they could step in and authorize the stay-at-home orders, no problem.
Right. Okay. So that we think is fine. Now, do you think that the reason that they're avoiding constitutional arguments is to stay out of federal court, or do you think that that the constitutional arguments are problematic?
So I don't think it's I don't think it's just to stay out of federal court. Because it's interesting in the Wisconsin case, right? One of the concurring opinions, the one by Justice Bradley, Grassel Bradley, as there are multiple Bradleys on the Wisconsin Supreme Court, goes on and on about how this is all unconstitutional, but under the Wisconsin state constitution. So that kind of ruling would also be immune from federal court. The Wisconsin Supreme Court said our constitution doesn't let the executive do this. That's up to them. So that can't be why. Now, it could be just because the Wisconsin Supreme Court, contrary to what some people are saying, is a reasonable, moderate court. It's trying to avoid doing anything more aggressive than it has to resolve the case. Is that a silly theory?
Yeah, I don't know. I don't know if that's what's going on here or not, because I feel like there's a disconnect between the public discourse and then these legal opinions that are coming down. So the legal opinions, it's conservative judges that have struck down Democrat actions. You haven't seen the inverse in Ohio or Maryland or other places. And so these are the cases that we've seen so far. Now, it's a small sample, things are moving fast, whatever, so this might change by next week and I'll look silly seeing this. But what's weird, though, is that you have a public discourse and a legal discourse that are sort of different, right? Which is the people that are on the news and writing columns saying how ridiculously illegal this is, I don't think they've ever double-checked the statute in Wisconsin that authorizes emergency orders from the Department of Health and the Department of Health and Safety to take actions, right? They're making some sort of due process argument or right to assembly or just sort of general appeals to liberty, implying that these things are unlawful. But then what you have is judges that are finding sort of administrative law ways to strike them down. And it seems like bending over backwards to do so, right? Like rushing to issue these orders on ad law reasons, quickly, short turnaround, emergency hearings, straining precedents while doing it. And so it seems like it's more than just narrow decisions, judges doing their job the right way, the way that you sort of tried to charitably frame it.
Well, so I feel like this mismatch happens though all the time. So this is the plight of anybody in law school who teaches administrative law or any subject like that. So, think of the fight about Trump adding a question to the census. It eventually is struck down by the Supreme Court on like a technical administrative law ground. One out of like 4 grounds, but it's reported in the news as like the court standing up to a president who lies or discriminates or, you know, whatever it is. I feel like this is the plight of administrative lawyers, is you like find technical grounds for things people care about for other reasons. But I feel like this is not so surprising even. So suppose we take the conservative sort of like lockdown skeptic. Not saying this is my view, but suppose we assume that view had something to it, right? The view is something like governors across the country are using this emergency as an excuse to aggrandize their own power and, you know, put themselves in charge of everything the way authoritarian executives love to do and the way our founding fathers died to stop them from doing. If that were true, it would not be a surprise that those governors were running roughshod over the statutory frameworks that governed them, stretching the powers previously granted to them, violating previous judicial precedents and judicial norms. Like, that's what you would expect a power-hungry authoritarian person who didn't care what the law to do. So then there then happened to be a legal defect in something they did. That would be what you'd expect, and then that's how the courts would stop them. They'd say, aha, in your attempt to aggrandize power, you forgot to issue an emergency rule subject to a 150-day limit.
Yeah, I guess. I mean, it's so weird, though, that, you know, this Wisconsin case, you have a, you know, majority of both houses that's Republican held. They could go past rules. In the Illinois case, there's a Democratic majority in both the state Senate and the state house. And today, my understanding, today is the first day they've met in 2 months. They're meeting this afternoon. So it's not like they're in a hurry to go double check the governor here. You know, and so we've got state elected officials. If they wanted to, they could have gone to the state house and tried to at least, you know, hold the governor accountable in some way. And so it's not just that like governors are running roughshod over the political process entirely. You know, this is using the courts to try to enforce, you know, to strike down these stay-at-home orders. And now what's weird is part of the argument against striking them down is like, we were willing to let this fly for a little while, but it's now been 60 days. So we need the courts to step in. But the same argument can be made about the political branches, right? It's been 60 days. So why don't the legislature step up and at least try to pass it? So.
Well, but maybe that's where it's good. So again, an advantage of the courts using statutory rulings rather than constitutional rulings is that it encourages legislatures to step up. So if you step away from legal technicalities, you have a framework, something like, when this first started happening, it was happening fast. We didn't know it, you know, we didn't know what to do. We didn't know how broadly or swiftly to act. We disagreed about that. So we just let the governors, you know, step in and make hard choices. But at some point, this is going to last for a couple of years. At some point, you know, we need to have a deliberation with the hard choices that isn't just one person's view. And I guess that's the legislature. So then it's kind of good that the Illinois legislature and the Wisconsin legislature now come together and decide what to do. And, you know, the Illinois legislature probably will largely ratify everything Pritzker has done. The Wisconsin legislature probably will not. And that's the, you know, consequences of people in Illinois electing Democrats and people in Wisconsin electing Republicans. And that seems like that's the kind of basic federalism democracy thing we're supposed to all believe in.
So let me ask, if there were constitutional claims that were either due process claims, taking claims, anything, do you think that this could get anywhere? I mean, there are lawsuits that have made these claims in courts everywhere, but and it's only the narrow ones so far that have gotten attention. The North Carolina church order, the federal court issued, the Kentucky one on Easter. Here are the cases that are getting traction. Do you think there's a broader due process argument? Right. So this argument was made today by, or recently by Ella Solman, right? So what's that claim?
Ilya Shapiro.
Sorry.
The two libertarian Elias, so everybody confuses.
Yeah.
So the theory is that, you know, everything the state does is subject to some kind of judicial scrutiny. And while we have, you know, a police power and broad deference, you know, a lot of the time, you know, at some point, vast restrictions on liberty need to be justified. And at some point, justifications run out. I mean, a kind of classic balancing test. I guess I've gotten in trouble before for saying, no, I don't think the courts are going to go that far, but I'll say, no, I don't think the courts are going to go that far. I think if you took that theory seriously, if you took sort of a takings clause theory or a due process theory seriously, right, that would apply everywhere, because that would be a federal constitutional rule. So it'd be a federal court, and that would apply a sort of level of scrutiny everywhere. And that would require, ultimately, you know, the Supreme Court to think that it could step in and open up the country nationwide. And I don't think that's going to happen. Do you disagree?
Yeah, I don't know. So do you think though, so here's what's going to happen, right? There's going to be some states where the way that the statutes are written are different, right? So maybe in Wisconsin, it really is an overstepping of the emergency powers granted to the executive branch of the state to take these actions. But maybe in California, it isn't, right? Maybe in California, they issued the emergency rulemaking properly, or that it's clearer what you're allowed to do. I haven't looked at the California statutes or whatever it is that's authorizing what Newsom's up to, but you could believe in one or more states that these languages are clear about what the government's about to do. But there's going to be people that are mad in every state. There's protesters in Illinois at the state capitol. There's protesters in California, Arizona, Texas, Michigan, wherever, right? Left, right, blue, red, and there's protesters that are upset. And there's judges of, all bents, ideological bents, in the federal court and in the state courts, in all of these places. And so it might be the case that there's not a good way to get to a statutory ruling, but there are people, or, based on the administrative law and the procedures, but there's people that are mad. And so, it seems to me that it's quite possible that there's going to be judges that are willing to, issue opinions saying that these are due process violations.
Yeah, so I guess here's my prediction is that in state courts, we'll see some of that. Like state courts have a record of being more activist, at least some of them, with respect to their state constitutions than the federal courts are these days. So I think it's easy to imagine, even the Wisconsin Supreme Court, if the Wisconsin legislature did authorize, more limited shutdown, but going on for a while, that in 6 months, it's easy to imagine the Wisconsin Supreme Court coming back and saying, all right, this has gone on too long, Thomas Paine said he believed in liberty and he somehow drafted the Wisconsin state constitution and, we decided to stop this. I still think for federal courts, what you'll see is more of what we've seen so far, where federal courts care more about like specific enumerated rights. So you'll see them saying you've got to treat churches equally. You'll see them saying you can't shut down the gun stores. You've got to make abortions available. Maybe we'll see something about voting. But I don't think you're going to see a generalized, unenumerated liberty claim from the federal courts.
Right. So a lot of the claims seem to be of a lot of the claims that are being brought by businesses are making arguments like, my business is being shut down. However, there's these other businesses that are being considered essential or that for some reason are allowed to be open, and that the lines that are being drawn don't seem to do a great job sort of lining up with public health considerations. So do you think there are any grounds for a due process claim saying like it's unfair that I'm shut down as an accountant, but a law firm is considered an essential business, or whatever these lines that are being drawn on?
Yeah. I mean, so yeah, I think like some of these claims are probably true, right? Obviously, like a lot of the line drawing is crude, and sometimes, why is it that florists are an essential activity in Delaware but not in other states? Like I think there are probably examples of this. But I think it'd be really hard for federal courts to strike it down. In a way, this was one of the things that was the constitutional arguments that was squarely rejected when we moved away from the Lochner era. And in these equal protection cases where businesses would say, why do you have a law treating opticians different from optometrists? Why do you have a law saying that we can't put non-milk fat in our milk? Why do you have, all these various some of them irrational business regulations? And the Supreme Court said, look, these all get rational basis review. If they don't involve kind of marginalized groups or real civil liberties, we don't really care about them. I think it's hard to imagine this being the case that leads to that being resurrected. In the past 20, 30 years, there have been like a handful of cases where a federal court strikes some regulation like this down, usually when it's totally clear that its purpose is protectionist. Why can't you buy a casket on the internet? And there's no good reason other than to protect the in-state casket makers. But you have to really reach striking this down.
Yeah, that seems right to me too. All of these claims that are saying essentially, it's ridiculous that my business is shut, but this other business is open. A lot of them seem right to me, that there's lines that are being drawn because, you had a handful of people trying to quickly figure out where to draw lines for entire states with thousands of different businesses of different types, sizes, industries, whatever. No one can even get all of them in their head, let alone, in advance figure what these are out, in a week. when these orders were being written. So of course there's weird arbitrary lines being drawn, but that just seems true of all state regulation to me, right? So all businesses, or at least many businesses, restaurants, bars, clubs, whatever, fire marshal says how many people can be in their business. The way that they figure that out is the fire marshal shows up and looks around, and then says 300 can be here, 100 there. Now they have some rules of thumb or whatever, but there's going to be arbitrary distinctions that are drawn constantly on the way that things are regulated, zoned, whatever. Why zone this block but not that block, whatever it is. This seems no different to that than me.
Yeah, I think zoning is a good example, right? Like, why is it that on my land I can't build I can't run a farm, but on your land just outside the city limits you can run one? Well, it's just because you're on different sides of the map, and the legislature literally has to draw lines. So I tend to agree about that.
I don't find the due process claims very promising, but they now seem to be being made. We're seeing these in
yeah. Well, so here's the one thing about it, and that makes me wonder if this is different, is that normally regulation is sort of like everything is permitted unless it's specifically forbidden, and then we go through and have lots of industries where we then impose restrictions on them. But like the default is you can do stuff until we come in and say you can't do stuff. One consequence of all the lockdowns is it's sort of the reverse. It's like everything is forbidden unless we specifically put your business or your activity on the good list. And it seems like that does necessitate just a lot more sort of weird and arbitrary line drawing. And it seems troubling to me. And I wonder if we have to do it that way. I wonder if we couldn't instead say, at least, not now, but in the next phase, look, whatever you're doing, whether it's essential, like a grocery store, or totally frivolous, like, whatever, as long as you do it standing 6 feet apart and wearing masks, it's okay. Rather than making you kind of prove that what you're doing is important. Like, is alcohol as important as groceries, et cetera.
That seems like a more sensible way to do it to me in many cases, right? To come up with whatever we think are the safe policies, the number of people that can be in the same air conditioning system, the number of feet apart, whether or not you have to wear masks in certain circumstances, whatever it is we think the rules are, and then just issue those principles instead of trying to come up with a good list and bad list for businesses. That makes sense to me. But here's a question. A lot of this is essentially people asking for extremely aggressive judicial activism, right? People are basically calling for the courts to bail them out. And these to me seem to be the same people that have been mad about the courts being activists, as long as I can remember. Feels weird, right? Like we've immediately flip-flopped on these roles.
Oh, you missed the memo. About 15 years ago, maybe it was 10 years ago, the conservative movement started rebranding judicial activism, which is bad, as judicial engagement, which is good.
I did miss that memo. That's the current edict of what you're supposed to call whatever it is. Okay, judicial engagement is good.
Judicial activism is when judges legislate from the bench and they make up the rules, and that's bad. Judicial engagement is when judges actually pay attention to what the law is and enforce the law. Thus proving that they're not potted plants. They won't just stand by when the executive and legislature ignores the law. So making up the law is bad, but enforcing the law is good.
Got it. Okay. And in this case, it would be engagement to come up with these rules. Now,
that's the theory.
All right. So do you think it's probably, our colleague Eric Posner has this argument that he's been advancing, saying that it's problematic, the asymmetrical power of courts, right? And the idea being that states right now, the Wisconsin state legislature, or in the case of Illinois, a specific Republican legislator, one guy, or businesses in Oregon have been able to bring these lawsuits saying, I'm wronged, my liberty is being restricted, my rights are being violated, the emergency orders overstep the statutory power, whatever the argument is, right? So specific people are making these arguments that you roll back these orders. But at the same time, if you were someone that's immunocompromised or elderly or just concerned about the virus or whatever else, there's no real mechanism for you to go bring a case against, for instance, the state of Wisconsin right now, saying since the last 7 days, your government hasn't been keeping you safe and that people are spreading these things like crazy. And now you can't go out at all because if you do, there's going to be hordes of people that are spreading diseases without masks going to bars every night. Or whatever your claim may be. seem problematic to you, this one-sided asymmetry, and the courts can strike down these measures, but they don't seem to have any mechanism right now to enforce them against states that don't have them?
Right. You can sue to stop a shutdown, but you can't sue to start a shutdown.
Right.
I mean, so I think that asymmetry is probably right. I mean, it's probably right that there is that asymmetry.
I mean, descriptively it exists, right? Okay.
Yeah, descriptively I think it exists. Although states are weird. States may have more of these weird procedures than we know about, where some legislature could step in and demand the shutdown, and who knows, the Illinois Supreme Court might deliver one if they needed one. But I think descriptively it's right. I'm not sure what we're supposed to do about it, though. I mean, I guess you could imagine, therefore, concluding, which I think is what Eric would say, therefore, if you're a judge in the Wisconsin Supreme Court, you should uphold these things. You should say, well, even though I think this is kind of illegal, I should uphold it because on average, courts strike down too many of these things, and so I'm going to kind of do my part to even out the odds. But I'm not sure that we want judicial review of kind of big questions to work on averages. I don't think we want to say the courts usually enforce the First Amendment a little too much, so they should sort of arbitrarily rule against the First Amendment rights to kind of balance it out.
Right. Does seem weird.
So maybe if the message is, somehow we should reform the system, writ large, that would make sense to me. But I'm not sure it really tells us what the courts are supposed to do.
Yeah, I mean, the Eric version would be just keep the courts out of this entirely, right? And that the court should recognize that they should let the political process play out
right.
In this way. Now, I don't know how promising that is to actually just assume that the politics will work itself out in any sort of medium term within a given state, especially, the earliest elections are November, I assume, basically anywhere. And so,
right. Also, I mean, since we started with the state courts, for federal courts, I get that. For federal courts, I get, stay out of politics, let the politics work itself out, don't try to inject yourself. I think the federal courts have been better about that. But the state courts, they're kind of part of politics, right? The Wisconsin Supreme Court elections are some of the most contested and engaged elections in Wisconsin. In very few states do judges have life tenure. They're often subject to some kind of re-election. So in a way, they're part of the political process. And it would be weird to say to the Wisconsin legislature, you should sit this out, let the governor handle it, right? Because we think no, the legislature's there, that's part of their job. So maybe the Wisconsin Supreme Court really is just a kind of another legislature.
Yeah, right. And they're just making their call whether or not they want to take these risks or not and see what happens.
I mean, that would be bad for the judicial activism brand question we were talking about earlier. But state courts do seem to be, a little bit more close to the process.
So let me ask you about this rebranding thing, though. Within this rebranding, what about the political question doctrine? This feels like a pretty good time to use avoidance doctrines if you're a court, right? We've got all kinds of ways that you can get out of this. Get out of these situations. It seems like a good time to fire those up.
Yeah, well, so these doctrines are complicated for this rebranding process. Yeah, I mean, so yeah, you can get out of them, but I don't know. So I gather in Wisconsin, they say this, our decision whether to take these cases is kind of discretionary decision whether we want to be involved or not. But I feel like this is just the same problem. It's like a court that decides it doesn't want to be involved in the biggest sort of legal dispute in the state in years. What's the point?
Right. I guess. I mean, that's though on the Supreme Court, when the Supreme Court uses the political question doctrine for a range of, for instance, limiting the president's power during a war that we could say is one of the biggest issues ever, maximally important, and that's exactly when the court does stay out, right? And
although so think of the last time the court used the political question doctrine was just last year to say they're not going to get involved in gerrymandering, right? They're going to let but in the course of saying that,
in Wisconsin, by the way, which
yeah.
But
in the course of saying that, the Chief Justice approvingly cites several state court decisions where the state courts got involved and regulated gerrymandering, sometimes on a pretty thin textual basis, like our Constitution says, elections have to be free and fair or something. So that's fine; they can do that. So again, I think the model is no one size fits all constitutional law from the Supreme Court, but the state courts want to do that,
Right. I guess. All right. What do you think about the takings argument? We've been explicitly asked in the comments here.
Yeah.
Review on whether or not we can call anything a taking.
Is the shutdown a taking? No, I don't think the shutdown is a taking. I mean, I think doctrinally, the police power is an exception to normal takings doctrine. So when you shut something down because of an immediate deadly disease, or tell an orchard they have to get rid of all their trees that are causing pollution, you can just do that without anything. And also, when takings are explicitly temporary, they get a much broader berth. So I think it would be different if this were like a permanent lockdown. We said like, you could never again run a movie theater in the state of Wisconsin. That might be a different question. But those two things together, I think, mean, as a matter of doctrine, it's not a taking. And we talked about this a little bit before in a previous talk. If you wanted to come in and ask Richard Epstein to remake all of takings doctrine, maybe we could come up with a theory under which this is a taking. But even so, the fact that it affects everybody so broadly, and it's sort of, theoretically for everybody's public good, I think makes it hard to say it's a taking even under kind of radical theories.
Yeah, it seems to me that it's a pretty tough argument to make. In part, not only is it temporary, hopefully temporary, some amount of time, that there'll be an end game to this. Two, we can use the stock markets and equity markets as some evidence that there's good predictions that businesses will exist in the future. Maybe not all businesses and the same businesses or whatever else, but the idea that the government has, evaporated all value to businesses is not really plausible right now. So, I think a complete regulatory taking argument for almost all businesses would be really tough to make right now. I'm sure there's exceptions that under Penn Central you can get to an argument that there's been a regulatory taking, but it's tough. But even differently than the normal taking case, here the claim is that the existence of the business or the operation of it imposes a health and safety risk to others. That is, there's an externality. In the standard takings case, so many of them, we think that it's not that your business imposes an externality, it's just that we want to build a highway through here, right? And when you do impose an externality, then we just get to regulate it, right? We get to zone you, limit your output of carbon or pollution or whatever else, and here we get to limit your, spread of COVID. And so it seems like a pretty tough case to make to me.
Right. I mean, the cases that would be the strongest would be to use the takings argument as a hook for these arguments that my business is being treated unfairly compared to other businesses, or my business is being regulated but doesn't actually impose that big of a public health problem. You'd say it's one thing to regulate a business that really does impose negative externalities, but look, if you let me, teach personal training classes in the park to groups of 5 people, our externalities will be nil.
Right.
And there, at least I see the theory.
I see the argument for why it's that those are bad policies that we should eliminate. Whatever these sort of regulations that aren't based on science. But the idea that we should start calling them takings, that seems like a really tricky doctrine to have going forward. To have the courts be able to look through exercises of regular police power to figure out when it's a takings.
Yeah, I agree. Although one price to that, right, is if the justification for the police power is, well, the state has to regulate externalities, it's for the good of all of us, so we have to help them do it. And then you say, well, what happens when the state starts regulating things that don't actually impose externalities and are not for the good of all of us? Then it's a little funny. We're like, oh, well, we let them do that too. Too hard to tell.
I guess, I mean, right. It makes some sense.
It just makes the first story seem a little bogus.
Right. All right, should we ask if anyone wants to jump in with questions here? A lot of these
Yeah, we just got another one in the chat I'm curious about, though. That's if the president were to have ordered a nationwide lockdown, imagine FDR, how would the Supreme Court likely rule on whether that's unconstitutional? And if other people have other questions they want us to address, just go ahead and toss them in the chat as well. But I'm curious, Adam, not that the current president appears to have ever been interested in ordering a nationwide lockdown, but if you imagine that he was, do you think he would have gone away with it?
No, so I think that it's problematic. So I'm not sure, there's probably some, act of Congress and some federal statute somewhere that gives broad health emergency powers. But I think it would have been a bit of a stretch. especially if it tried to limit movement between states or other other steps like that, without some explicit congressional authorization. So I actually do think there's a good chance that the Supreme Court would strike it down.
Yeah. I mean, I think the president I think of when we get asked this question is not Franklin Roosevelt, but it's Harry Truman,
right?
Who tried to seize the steel mills, during the middle of the Korean War, to sort of help the war effort, and the Supreme Court was willing to take the case very quickly and say, no, you can't do that without statutory authorization from Congress. I think the interesting question that I'm less sure about is, would the Supreme Court have acted slowly or quickly? Because you could imagine one path would be the Youngstown path. If there were a nationwide lockdown, the Supreme Court quickly steps in, here's the case super fast, and says, no, the ball's in Congress's court. The other path, which is one the court takes a lot of the time during war, is to take your time to hear the case and wait a couple of years. And eventually the Supreme Court would say, no, the president can't do that, but it wouldn't rush to make that happen, just in case we actually needed the lockdown. They'd avoid putting it in place too quickly.
I do think that a lot of our doctrines on this seem to be poorly tailored to a pandemic scenario, and that I think we're still getting the evidence, but it looks like so much of the spread of the disease around the country is Manhattan emptying out in late March. And so that's like New Yorkers leaving that carried the disease everywhere after people were afraid in New York. And that's, tens of thousands of people that were spreading the disease. And at least initially, even though New York's in a lockdown, other states were not in a position to stop them leaving. Trump teased in a tweet that he might order this tri-state area to lock down. And this actually got people upset, but it actually, in retrospect, might have been, if we could have done that quickly, the best possible step that could have helped save the rest of the country.
Right, exactly. I think, I'm not sure there would have been any statutory authority for the president to do it, but if you imagine he just ordered a huge amount of federal authorities to blockade New York illegally, and that would have taken a month for the courts to finally strike it down. Could have saved a lot of lives.
Right.
What's the point of having an authoritarian president if you don't get to at least,
Yeah, that's right. At least don't get to take some of these steps. Right. Sure.
Yeah.
I think the court would have gone slow. I think courts, at least initially, were afraid to act too quickly in this area, right? And it's only after we've settled into this sort of current phase where it's unclear what's happening that courts are seem a little more willing to take these actions.
Yeah.
All right, here's a question. Thoughts on the DOJ's letter to California arguing that reopening plan may violate the FRA by not reopening tortures at earlier stages. So on that, so the religious stages seem to be, these religious cases do seem to be one place where we've already had multiple federal courts willing to get involved. The Oregon order that was stayed came out of participating churches. And then there's been cases in Louisiana, Florida, all over about the church cases. Now, on the one hand, churches are obviously protected by the First Amendment, but on the other hand, on this, they are also sort of, in many cases, by definition, a mass gathering where the goal is to get more than 10 people together. So if the state, in the case of California, says you have to be 6 feet apart, you have to wear a mask, but other than that, you can still have your service. As long as you socially distance, don't shake hands, maybe don't take communion, these other things, as long as you're consistent with all the other policies. Is it problematic to leave you to the later phases?
Right. So I think this is tricky because I think this gets into a little bit of what we're talking about earlier. So I think if the state is trying to assess the benefits of religion, is trying to say, look, you can have, in-person gatherings for things that are important, like buying alcohol, but not for things that are unimportant, like worshiping God, I think that's a real problem. I don't think the First Amendment lets the state say that religion is less important than alcohol, or than whatever. You kind of have to put religion. I'm not even sure they can say religion is less important than food. But a church service is different from a trip to the grocery store, or a trip to the liquor store, in ways that seem to matter from a public health perspective. We seem to think having people in one place for a protracted period of time matters, and most people don't spend an hour sitting there at the grocery store, even 6 feet apart. Things like talking and singing seem to make things worse, so that seems like a problem. So I guess I think if they really are treating churches similarly to other activities of the same risk profile, that should be okay under both RFRA and the Constitution. But the problem is if they're saying that, we just don't think this is sufficiently essential. Now, that could look really awkward because it could actually be as a public health matter. The right answer is you can have church services with social distancing as long as the congregation is not permitted to speak or sing and the officiant doesn't speak very loudly. That seems like it's way more intrusive and itself something that would really trouble us, but that might actually be the sound thing to say.
Right. If you keep churches in the same bucket as schools, right, which have so many of these same features, schools, universities, whatever, people in the place for a long time, that people might be expected to talk or whatever, although I guess there's more in the church case. Probably fine. I don't know. Although I could imagine some states do draw weird lines, and maybe then there is a problem if you're not equal. And I do think that is going to be one case that courts are going to be willing to step in, is the line drawing around churches, as we've already seen. Yeah.
So one other question we've gotten from a couple people in the chat, different versions of, is what about the kind of insurrection? So you see the state has a lockdown order, and then you see local counties, local sheriffs, various people say, well, we're not locking down.
Right.
And so, I wonder if this is actually a possible counterpoint to Eric's thesis. I think there probably are ways you could do something about your sheriff refusing to comply with the lockdown. I think you probably, certainly the state could, right? Certainly the governor could step in and threaten to enforce law directly. And I think there actually probably are doctrines that would let you sometimes do something about a sort of flagrant refusal to enforce the law by a local official. I don't know. What do you think?
So this exact issue, the insurrection issue, has been such an interesting kind of case the last few years in the way that people have thought about it and flip-flopped on it. And so the two examples that have been huge in political discourse generally recently have been the issuing of marriage orders. So this was the Kim Davis case. The state clerk saying, I don't care, I'm not issuing a same-sex marriage order, becoming a bit of a national celebrity over refusing compliance there. And then on the other hand, you have the sanctuary cities debate in immigration law, right? And both parties have very flipped on what they think is important on these two debates. The Trump administration has tried a variety of different tactics to try from courts to funding to stop cities and states like, for instance, Chicago, where we are, from not complying with the detention orders for undocumented migrants that are picked up within the city's criminal justice system. And so you do see this sort of split on what people's views are on the circumstances in which we should compel city and local officials to comply with federal law, though, which makes it slightly different. Here, what you have going on is cities and states that are saying that we don't want to enforce laws that are primarily state laws, right? And so, and that's a lot of what the insurrections are about. Sheriff cities, whatever, they're going in that direction. So it does slightly complicate it, what the enforcement looks like, and that presumably at the state level, there is going to be more authority for the governor to step in than there would be for the president to step in.
Yeah, I think that's right. Although I think even there, states do differ in how much autonomy their local governments have. So some states have a kind of stronger home rule principle where the counties have more like inherent authority, and some, say you're more just like a subdivision of the state. So, and these are structural questions that usually don't, usually come up in in less freighted contexts.
Yeah. Yeah, it is a difficult thing. So it's one thing when when you've got these mayors explicitly saying, like in the sanctuary cities cases, that we're not going to comply. But if a local police department just said, we're not going to pick anyone up, if we see people on the street or operating their business, we're not going to do anything about it. That seems a lot more difficult to try to do much to enforce about it, right? Using prosecutorial and police discretion about the enforcement, right?
Yeah, it seems harder. Although I will say, under current federal constitutional doctrine, it's very hard to get the police to do anything to enforce the law if they're not enforcing the law. But these are problems that states have confronted before, and at least sometimes there have been kind of forms of legal legal pushback. So, obviously after Reconstruction, you saw, like
after Broadway boards,
South, not enforcing the law, and sometimes there were federal remedies and federal things to say, no, being the sheriff doesn't just allow you to declare it like open season on whatever you want it to.
Right.
So we might have to dust some of that off.
Right. Reasonable.
I think that this gets back a little bit to the practical thing, though, is that in a world where these things are this controversial and where there's sort of different parts of the state or different parts of the country, support them at different rates, it's maybe less likely there really will be pushback. This is when the shutdown orders first happened. There's very little pushback for a while. Everybody is sort of hunkering down trying to figure out what's going on. The longer it goes on, the more impatient people get, the more they think things were overstated, or we just can't afford to do this anymore. And then you start to see some states and some areas say, well, we're not going to do it anymore. And that's what the Wisconsin are doing too. So maybe we're just in a new phase of bargaining over COVID.
Yeah, that part has been interesting. So I did right on March 15th, fielded a number of surveys around the country to get people's views on civil liberties on these questions. And my collaborators and I found huge support for various steps to take lockdowns that were nonpartisan in nature. So both Republicans and Democrats just broadly majority supported essentially everything. Shut the schools, shut everything. And we weren't the only people that thought to try to get those surveys into the field right away. There's some other research groups and people that did the same thing. And that was a consistent finding that there weren't really partisan or ideological differences in views in mid-March. That is no longer true, and there are huge differences now in people's levels of support for these things. Now, it's an interesting question why that is, that we've moved into our sort of tribal camps on our attitudes towards these things. But for a while, it looked like maybe COVID was not regular politics and that it was something different. But now it's moved into more like a domestic policy issue. That we're having these differences that are tough to shake. And I assume that's only going to continue, in part because it's become part of people's sort of identity or whatever else the positions they take on these things. And so it's been wrapped up into our political views, but also because there's inequalities in the way that these things affect us, right? So if you're a rural person, it's tough to understand, a person that lives in a rural area, I should say, it's tough to understand why you have to have these orders in place when the real issue is in particular neighborhoods in Chicago. So, Chicago, Cook County is now the #1 COVID hotspot in the country. We passed Queens a couple of days ago. There's more cases than anywhere. But if you're in downstate Illinois, the risks must be still, smaller than the average flood or something, or tornado or whatever it is.
And also, this might be a dynamic that you see all the time. So, like, you think of war, something happens right away. There's broad bipartisan support to retaliate against, whoever it is who caused the 9/11 attack or some major issue. But then the longer the war drags on, the more it starts, support starts to fray, and it's to fray along the traditional partisan lines. Or some people say, this may just be that we can temporarily put aside tribal politics when something seems like it's an emergency, but we also only give the governor 30 days before we go back to our.
All right, we're being told we're out of time here. Do you want to answer this question about the Hemmel tweet, or should we just?
You guys are welcome. You guys are welcome to keep going. I wanted to just give you a time check, but feel free to close this out with one more cue, and we can go from there.
Sure. Yeah. So this last question is about something one of our colleagues posted, noting that some states have different rules about where the ban, where too many people, where the ban on a gathering too many people comes. And the 10 is a magic number in Judaism because that's what gives you a minyan that you need for certain kinds of religious purposes. And so is it possible there's a sort of religious gerrymandering problem if a state says, the magic number for us is 9, not 10? Seems plausible to me. What do you think, Adam?
Well, if states really were to pick 9 and there was no science evidence, anything, and there was any evidence that that religious motivations factored into it, seems like a possible argument to me. I hadn't heard that though, so that feels more like law professor musings than facts on the ground, but it's possible, I guess.
Well, sometimes there is just a laziness about, if your number is 10, is it up to 10 or is it more than 10? Is it more than 10 or 10 or more? And people just write things different ways.
Yeah, the fact that we still have ambiguities around dates and times and numbers in this way is, a problematic problem for both the English language and us as lawyers and law professors in general.
Yeah. Let it be our problems. All right, shall we call it?
Yeah, I gotta go get ready to teach immigration law, so we should probably wrap it up.
All right. Thank you, everybody.
Adam, Will, thank you so much. We know your time is valuable, and we really appreciate you spending your lunch hour with us. We appreciate it.